Good afternoon, everyone, and thank you for joining us today. Today, I'm joined by my fellow partner, Anton Konnov, in our M&A practice at Altamimi & Company. Anton and his team recently contributed a chapter to the International Comparative Legal Guide, Mergers and Acquisitions. This chapter explores key aspects of M&A transactional work in the UAE landscape, including regulatory considerations, common transaction structures, and the latest developments shaping deal activity in the region. In this discussion, we'll take a closer look at some of the insights from the chapter and what they mean for businesses, investors, and deal makers operating in the UAE. To begin, Anton, could you give me an overview of the current M&A landscape in the UAE today and some of the trends you're seeing in the market?
Thank you, Richard, and good to be here. The EU market continues to be one of the most dynamic in the region, and what makes it particularly attractive is the continuation of a liberalized foreign investment regime, robust legal infrastructure, and strategic positioning as a gateway between East and West. One of the most significant recent developments in the continued liberalization of foreign investment rules is that the EU now generally permits 100% foreign ownership of onshore companies, with only a narrow set of strategic activities such as defense, energy, telecommunication, petroleum remaining subject to ownership caps and special approval requirements. And this has fundamentally changed the landscape for international investors.
That's a very helpful overview, and I'd also add that it's a common misconception insofar as we're not in a frontier market when it comes to deal sophistication, and that most deal structuring would closely mirror the sort of transactional structures and deal mechanics that we'd also expect to see in other jurisdictions in the Western world. Parties are very often using varying pricing mechanics, for example. Most transactions in the region will have the same sort of completion price adjustments that you'd expect, as well as deferred consideration, earnouts, etc. All of these are common aspects of an M&A transaction in the UAE. We've also seen the advent of warranty and indemnity insurance in the market now for the last couple of years, and that obviously is very attractive for deal makers. It ensures the ability for sellers to exit cleanly and also for fast and efficient deal making. Speaking of regulatory changes, Anton, I understand there's been some major updates to the competition law framework. Can you walk us through what's changed and how it affects transactions?
Absolutely. This is one of the most important developments for anyone involved in M&A in the UAE. The new competition law, which became effective in March 2025, represents complete overhaul of the merger control regime in the UAE. For the first time, we now have clear turnover thresholds that trigger mandatory merger filings in the UAE. Specifically, a filing is required where either the combined UAE turnover of the parties exceeds 300 million dirhams, or where the parties hold 40% or more market share in a relevant UAE market. That brings the UAE more in line with international merger control standards and introduces a level of predictability that was previously lacking. There have also been significant changes at the capital markets level with the establishment of the new Capital Markets Authority, placing the former Securities and Commodities Authority. And this new independent federal regulator has expanded authority, and we anticipate that they will implement regulations in such areas as disclosure, fair dealing, takeover transparency, and enforcement powers.
I think it's worth emphasizing the point around the competition law thresholds, because for years that lack of clarity has created uncertainty for deal makers, particularly in cross-border transactions. Having that clarity now is definitely a significant step forward for the market generally. So let's turn to the practical side. What are the common deal structures that foreign investors use when entering the UAE market?
M&A transactions in the UAE can be structured in several ways, but the most common are share purchases and asset purchases, with mergers being less frequent. The choice between the structures is typically driven by regulatory constraints, liability considerations, tax planning, and integration objectives. For foreign investors, it's also essential to understand that the UAE has multiple jurisdictions within the borders. You can set up companies in the mainland, commonly referred as onshore companies, in the form of limited liability companies, private joint stock companies, or public joint stock companies. Alternatively, you can operate through the various operational free zones, such as JAFZA, DMCC, Health City Zone, and through financial free zones such as ADGM or DFC. Each of these has its own regulatory framework, and the structure will depend on the investor's commercial objectives, their target's existing structure, and any sector-specific requirements.
Thank you. From a practical standpoint, I'd also note that free zone versus onshore is also a structuring decision and very much dependent upon the nature of the business, given the way that the commercial licensing regime works in the UAE. I'm going to put you on the spot a little bit, Anton. What would you say is the biggest misconception that foreign investors have about doing M&A in the UAE?
That's a great question. I would say the biggest misconception is that the UAE is just like doing deals in the Western markets. Alternatively, that it's very restrictive or bureaucratic. The reality is that it is somewhere in between, and understanding the nuances is critical. One key difference is the availability of public information. For private UAE companies, whether onshore or free zones, publicly available information is minimal and typically insufficient to undertake meaningful due diligence independently. Buyers are heavily reliant on sellers and target for access to information and due diligence support. This contrasts very much with jurisdictions where there exists public filings, disclosures, and you can obtain information independently. Another area where international investors sometimes stumble in is the share transfer mechanics. This can be more cumbersome than expected, requiring approval from relevant authorities here, and needs to be supported by notarized and, in case of foreign parties, legalized documents, which makes things more cumbersome and time-consuming.
I'd echo that. The documentation requirements in particular catch people off guard. We've had innumerable international clients come to us, and when we're assisting them, expecting that a transaction can be closed in a matter of days, perhaps we're one subpart of a wider deal, but those documentary requirements and the necessity for certain consents and approvals, depending upon the industry sector, is something that's really relevant, and being able to navigate that and ensuring to the extent possible that you can arrive at an efficient closing does require an element of forward planning. It is a process point, but it does have real commercial implications for deal certainty and timing. What about post-closing? What are the typical sources of disputes that the parties should be aware of?
Well, I mean, the most common sources of disputes in UAE M&A transactions relate to breaches of warranties and representations, much like anywhere else in the world. However, the key mitigation strategy have some local considerations. Transaction documents typically provide for buyer protections, such as warranties, indemnities, price adjustments mechanism, material adverse change clauses, and claim procedures. Sellers usually mitigate their exposure through robust disclosure letters and negotiated limitations on liability.
One important point that's worth highlighting here, and it's something that surprises parties coming from common law jurisdictions, is that if a contract's governed by UAE law, UAE courts have the statutory power to reduce agreed damages or penalties if they consider them disproportionate to the actual loss suffered.
Exactly, and this is different from English law or DFC, ADGM law, where commercially justifiable break fees or liquidated damages provisions are generally more enforceable. So understanding your governing law choice is therefore critical for risk allocation.
Which brings us to risk mitigation more broadly. How prevalent, Anton, are you seeing warranty and indemnity insurance being used in the UAE market?
W&I insurance is now well established in the UAE private M&A space and is increasingly used to enhance bid competitiveness and facilitate cleaner exits. These are typically buy-side policies governed by English law or DFC or DGM law, covering unknown breaches of warranties, tax indemnities, and they are subject to the usual exclusions.
That's right. And what's interesting is that in public M&A transactions involving public joint stock companies, the picture's quite different because the statutory disclosure obligations significantly reduce information asymmetry. And as a result, acquirers in transactions are seldom able to secure comprehensive warranty and indemnity insurance. And that's typically reserved for fundamental warranties only. So the risk allocation in public versus private deals looks quite different.
Oh, precisely. It's one of those distinctions that matter significantly in practice.
Before we wrap up, looking ahead, what regulatory or market developments do you think will have the biggest impact on M&A activity in the UAE over the next few years?
I would point to two developments. The first one is the new Capital Market Authority, to which I referred earlier, and anticipated implementing regulations which will shape public M&A market going forward. The creation of an independent regulator with expanded authority signals that UAE's commitment to robust capital market governance is very strong, and users and investors should be prepared to adapt. Second, the amendments to the Commercial Companies Law introduced in 2025, which are modernizing the corporate framework significantly. So we now, for example, have provisions permitting multiple share classes in onshore companies, and importantly, the express permissibility of including drag-along and tag-along mechanism in the Memorandum of Association.
The drag-along and tag-along point is particularly significant, I feel, for private equity sponsors and venture capital investors. These mechanisms are fundamental to how they structure their deals and protect their exit rights. Having express statutory recognition removes a lot of the uncertainty that existed previously. And I feel that brings UAE corporate law more in line with international market standards and practice, and provides additional flexibility for structuring investments and exits.
Absolutely. And taken together, these developments signal a market that is maturing rapidly and becoming increasingly attractive for sophisticated investors.
Anton, thank you for sharing these insights. For our viewers, the full chapter on UAE M&A is available in the International Comparative Legal Guide, Mergers and Acquisitions 2026. If you have any questions about transactions in the UAE or across the wider Middle East, please don't hesitate to reach out to us at Al-Tamimi & Company. Anton, thank you for joining me today.
Thank you, Richard, and thank you, everyone.